Okay, welcome back to another Law and Power case brief. This is one of my favorites. This is Lorain Journal v. United States. Standard disclosure, this is not legal advice. If you need legal advice, consult a licensed attorney. All right, let's jump right into the case brief. Okay, so this is a Supreme Court decision. It is from 1951. It was a unanimous opinion, 7-0. The victory was for the plaintiff, in this case, the United States government. The conduct at issue is attempted monopolization via exclusive deals and refusals to deal. The relationship between them is a little technical here, but sometimes an exclusive deal can be formatted to be a refusal to deal. This is also known as a conditional refusal to deal. Again, that's a discussion for another day, but the conduct here can accurately be described as exclusive deal, a conditional refusal to deal. The industry concerns in newspapers and radio. And the statute is our ever favorite, Section 2 of the Sherman Act, which prohibits monopolization and attempted monopolization and conspiracies to monopolize. Okay, on to the facts. So what happened? So you had a newspaper known as the Lorain Journal, or the Journal, and it was a newspaper in Lorain, Ohio, and the district court found that it had commanding and overpowering market position in the city. Over what? In antitrust, we care very much about the relevant market, or the market at issue. And in this case, it was over the mass dissemination of news and advertising. So what was the journal's market dominance? What was their market power, their market share? In this case, it was 99%. Which is a lot. It's almost 100. And critically here, the journal was perceived by many advertisers in the area that the journal was an essential medium of advertising. If you wanted the public to advertise your product, you had to use the journal. So what happened is a radio station comes along and poses a competitive threat to the journal. The main aspect was that the radio station, in this case WEOL, was seen as a alternative advertising source, or advertising medium. So, what did the journal do? Well, they implemented a plan they basically said that if you advertise with the radio station, you will not be able to advertise with us. Again, it's a conditional scheme, conditional refusal to deal, and another way of saying that is if you could only advertise with the journal if you were not advertising with the radio station, and really the intent behind this, the district court found, was that it was the journal explicitly engaged in this conduct to destroy the radio station. And the journal implemented an information gathering apparatus to make sure that their plan was being adhered to, and the plan was found to be successful. That advertisers stopped advertising with the radio station. So what's the legal question at issue? Well, the first one, or the main one, is the conduct an unlawful attempt to monopolize in violation of Section 2 of the Sherman Act. What did the court hold? The answer is yes. And the decision was really based off of two main factors. The first was that the journal really had a substantial monopoly for being an indispensable medium of advertising for many Lorain concerns. And under the Section 2, we really do view it's viewed that dominant corporations have a heightened duty to the public, that they are looked at with extra scrutiny. So this makes a lot of sense that the journal's dominance would be problematic. But just as importantly, especially for an attempted monopolization claim, is really the intent behind what the journal was doing. And here the district court found, quote unquote, found unequivocally that the journal's conduct was done explicitly to destroy WEOL, the radio station, and to regain the journal's dominant market position over the dissemination of news and advertising. And that's really the opinion. It's a short opinion. It's a very important opinion. I go into a lot more detail on the website which I'll show some of the links here. Here are some of the main links. You'll find this presentation on the first link. The second link is where you'll be able to find all the case briefs here, casebriefs.lawnpower.net, where I go into far more detail than this presentation. In almost literally every single word and sentence of the actual opinion is accounted for. The video presentation link will be available when this is published. You can see all of the briefs published on the website in this master database link. You'll be able to sort cases and whatnot. Feel free to follow me on X, Blue Sky, Mastodon, and all the links using at Daniel A. Hanley. I subscribe to my newsletter, danielhanley.substack.com, and you can find all my other links in the link tree. Otherwise, thank you so much. Look forward to the next one.